This is Legal Matters. This is the program that's been designed to address the critical and sometimes contentious issues that are facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of issues that will affect your home and work life. I'm Debbie Moraes, your host and moderator. We always want to begin the program by thanking from Bazar Law Firm in East Providence for providing their insights and their time to give us some better insight into what's going on in some critical topics today. Today, a hot one. It's going to be workers' compensation, one of the more contentious ones for sure. We'd like to welcome David Bazar. David, we wish Jackie were with us, maybe next time. So, we hear on the street, better not report a workers' compensation claim, you might lose your job. On the other side of it, sometimes we hear if you don't report that there's an injury on the job, you might not even be able to claim benefits later. I think we need to go back and talk about what workers' compensation is, because certainly that is a hot topic and so much fraud, and it's certainly a butt of jokes, unfortunately. David,
Sure.
give us the scoop.
So we'll get to those issues later, but the history of workers' comp. Workers' compensation actually was a law that came into existence as a result of the Industrial Revolution. So when we were an agrarian society, people worked for themselves for the most part. They got hurt, they worked through injuries or couldn't work or whatever. They relied on the rest of the community to help support them. With the Industrial Revolution and the injuries that became catastrophic through machinery and that type of thing, there was a need to try to find a system so that if a worker was injured and could no longer work and produce income for the family, how could the family survive? So there was a trade-off. At common law, which was all that existed for that worker, the injured worker, you would have to sue your employer. You'd have to prove that the employer did something negligently to cause your injury, and then you could recover. You could do that, and of course, lawsuits take a long time. So the trade-off was these workers' compensation claims were streamlined so they could be heard very quickly. And in the trade-off for that, the worker gave up the right to collect for pain and suffering and other damages, but was rewarded with a system where he no longer had to prove negligence against the employer.
So it can happen that there's an accident. That's different from the employer meant for something to happen. Generally not the case. In every state, is it true now that every employer has to have workers' compensation, some sort of insurance in case something terrible happens?
So it varies from state to state as to what the requirement is and what type of employment. In other words, in Rhode Island, it used to be 3 or more employees, the employer had to have insurance.
Yeah.
That's been changed now that if you have any employees, you have to have them covered with workers' compensation insurance. So the details will vary from state to state, but the ideas are the same. If you have employees, you have to protect them with workers' comp insurance or file to be self-insured, and there's a process to do that, which you can do through the Department of Labor. But in any event, there has to be a coverage or a plan in place that covers your employees in the event they're injured while working.
And for those who may have small businesses and being sole proprietorships or even just a corporation with 1 employee, do they have to have some coverage too, or are they exempted from that, at least in these parts?
Sure. If you have employees, you have to have insurance. If you are the owner of the business, there is an ability in most instances to opt out of the insurance for yourself. It's probably not a great idea because workers' compensation insurance isn't all that expensive, but the bottom line is if you have people who are working for you that are not owners of the business, then you have to have the workers' compensation insurance in place. And if you don't, there is a penalty to be paid for that.
Okay, so let's assume that the employer does have insurance and an employee is hurt on the job. Before we rush to let's go get a lawyer, what should actually happen in most cases when there's an injury, not fraudulent, a bona fide injury? What should happen, David?
And most injuries are not fraudulent.
Sure.
They're legitimate injuries that happen in the workplace, and that's why we have the insurance in place. So I will talk about it a little bit from both the employee and the employer perspective. The employee, if he's injured at work, needs to report it to his or her supervisor immediately so that they can make note of it. The employer has a duty to file a report of injury to the Department of Labor within a reasonable period of time. I think it's within a few days, but once there's an injury that's been reported, they have an obligation to report it.
So as I opened up the segment with, gee, you better not report a workers' comp issue because you could have some retribution or lose your job. Can that happen? And what happens if you suspect that there's some retribution?
Again, there's some protection in the system for that. If you're hurt at work and you're out of work for a period of time, but it's not that long a period of time and you know you're going to get back to work, the employer is supposed to keep your job open for you. It's really sort of a nebulous and difficult right to enforce. It's in the law and it's clearly there, but to go to the Department of Labor and file for a hearing and try to get your job back can be a little bit difficult. Most good employers and most good employees will work with each other to make sure that the job's still open, that they have a job to return to. Now, it's difficult if you only have 1 or 2 employees. You have to do something, maybe bring in a temp or do something like that. But the long and short of it is, if you're hurt at work and it's a serious, legitimate injury, you need to report it, because down the road, if that gets worse and now you're unable to work, going back and trying to unring that bell that you ring saying, I got hurt but it wasn't at work, is very difficult.
And continue with that. The other issue that I brought at the beginning of the segment, if you don't report it right away, there's a chance, as we're told and as we've read, that you would be denied claim or payment later.
Benefits,
what is
right.
that? What's that time frame? How does that play out, David?
Well, the problem is this. If you get hurt at work and your employer says to you, well, just go and tell them you fell at home or something like that. Don't report it as a work injury, and I'll make sure the medical bills get paid, and you go back to work and you're still working. But it turns out you have something more serious and can't work. Now you have to file a workers' compensation claim. You file that at the workers' compensation court. You have to send notice. They have a time frame to answer. And then what happens is you get the medical records, and all of the workers' compensation claims in court are really processed through your medical records. There's testimony as to what happened and how it happened and all of that, but the records as to your injury and what the doctors and medical providers have to say really carries a lot of weight with the court. So if your records now come in and they say, I fell at home, and you're trying to say, well, no, that's not really what happened, that's not a really good posture to be in when you're trying to prove a case to the court and your employer is arguing against your getting on workers' comp in the first instance.
So should you be suspicious if you go to HR or that supervisor, as you indicated, and don't worry about anything, we'll just take care of it? You are not to assume that they're going to take care of it through workers' comp and just that something happened and you're dismissed and you can just go to the doctor and everything will be fine. Should you be suspicious of that person and immediately call a lawyer, or just go in faith that they're doing what they're supposed to be doing the way that they're supposed to do it?
I don't think you have to be suspicious initially out of the gate. If what happens is you go to your employer, you tell them I was hurt, doing this, that, or the other thing, and then as a result of that injury, you need to go to see a medical provider, as long as when you go to see the medical provider, you tell the truth and you tell them exactly how it happened and where it happened.
Okay. And while someone is involved with workers' compensation, what happens with what's in place for them at work? Their sick pay, their pool, if that's what they have, their retirement contributions, their dental, all of those things. Do those things stay intact as they were untouched?
So if you're injured and you're on workers' comp, there are certain things that continue to happen and certain things that can be changed. For example, under the prior law of workers' comp, if you got hurt at work and you had medical benefits, health insurance through work, that would continue. There's a law on the books that says your health insurance has to continue as if you are employed. There's also a federal law called COBRA, and the COBRA law kicks in, and so what happened was there was an issue. Which one preempts the other? Does the workers' compensation law prevail, or is it COBRA? And since it's federal, and most times federal law will preempt state law on this issue, that's what happened.
Okay. And would it mean that if you suspect there's something not looking right, that's at that moment you call a lawyer? Is that a trigger? What are the triggers that tell you you really do need to have somebody else working on your behalf?
Okay, so let's go back to the beginning, because we never really addressed that issue. In workers' compensation, you should always have a lawyer. And the reason I say that is because the way the system is set up, if there is a fee to be paid, primarily for a petition to get on comp, for a petition to review your status on comp, for loss of use and disfigurement. We can talk a little bit later about the other benefits you can get on workers' comp. The insurance company pays your lawyer's fee. So you're not paying the lawyer anything out of pocket to hire a lawyer. The second part is, if the case is ever settled, a lump sum or commutation as they call it, then you do pay a percentage, 20% out of the lump sum, but you're never paying directly out of pocket for the lawyer, so you should have a lawyer. And why? Let's start from the beginning. You get hurt, the insurance company starts to pay you for a period of time, so you think, oh, everything's all set, I'm getting my workers' compensation payments, getting my medical treatment, but they could be paying you under what's called a non-pred or non-prejudicial agreement, which means that, yeah, we're going to pay you, but we're not accepting liability for the claim. We're not sure that it was a workers' compensation injury.
So excuse me for a moment, how would that employee without a lawyer know that? Is there something that's written in a form that tells them that?
There is a piece of paper.
And you hope that they know it?
Yeah, most people won't. They
Sure.
just will see their name, what the amount of the benefit is, and they won't see that it's not a memorandum of agreement, which is the proper document to be paid under, because now you're protected. If you're paid under a memorandum of agreement, the compensation carrier, the insurance company, can't just stop paying you. They have to go back to court and say there's been a change, here's the change, and then they can stop paying. Under a non-pred, they can stop after a certain period of time. In fact, they have to stop after a certain period of time. Otherwise, it becomes binding anyway.
You mentioned earlier about the fee structure. Is there a flat? I noticed that in Massachusetts they have a set of fees that range, and then also percentages that lawyers will have when it comes to settling workers' comp. Does that vary state to state? And should someone be aware of they live in one state and work in another? Is that all under the jurisdiction of what a lawyer would advise you to work with and send your claims to?
Sure. So you've raised several interesting questions in one question, or several issues. The first issue is, yes, it can vary from state to state. Every state has its own workers' compensation law. The procedure is different in every state. The fee structures are different in every state. But particularly in Rhode Island, there's no fee schedule for attorney's fees. They're set by the workers' compensation judge. There's a fee schedule for medical payments that the doctor gets paid or the medical provider. But the bottom line is the 20% that you can get in a lump sum has to be approved by a judge. That's just the max that's put into the statute. So the other issue you raised was jurisdiction. Well, I was hired in Rhode Island. I work in Massachusetts. In fact, I work in several other states. What state do I file my claim in if I got hurt as a bus driver for Greyhound in Vermont? Well, the answer to that question, because it's actually a case that we've had, is it's where you're hired. So if you were hired in Rhode Island to do a job that's primarily out of Rhode Island but takes you to different places, even if the injury occurs in Vermont, in that instance, you could still file in Rhode Island.
That's good to know, an important point to know. When it comes to someone collecting benefits, maybe they don't know exactly what the benefits are, but they know that their medical bill has been covered. Is it possible that someone could just assume that it's workers' comp, not having read this non-pred claim, and then have a letter come from their employer that we're either challenging or denying workers' compensation benefits? Can that actually play out that way?
Sure. So if they pay you for 3, 4, 5 weeks, whatever, on a non-pred, and then decide, you know what, we're not accepting this injury, they can just stop paying you. Now the burden's back on you to file the petition in workers' comp to get the case heard in front of a judge. So the memorandum of agreement, which is the controlling document, or the non-pred, or if you do go to court, the pretrial order or a trial order, those documents are very important in your case, because not only does it set out what your benefits are, the average weekly wage, which is what your payments of workers' compensation benefits will be based on, but it also sets out the nature of your injury. So if you're on workers' comp for an arm injury, a right arm injury, but it's really right arm, shoulder, and it's flowing from an injury in your neck, you need all of those body parts listed, because if the doctor for the insurance company on an independent medical exam sees you and says, right arm's fine, well, yeah, but my neck is still bad, and that's not listed in the petition or the document of the pretrial order, you're going to have some issues.
So I know on countless occasions, or actually I should say on just about every occasion, you and Jackie would say it's always about documentation. An average employee would know perhaps that he fell on something that was at work. Maybe he even had his cell phone, he could take that picture. Okay, that's a form of documentation. If someone doesn't have his or her ducks in a row yet, what other kinds of documentation, other than the obvious like a lab test or a doctor's CAT scan request, or what other kinds of documentation would someone need to be aware of, and would you likely ask to try to put in your arsenal?
So in a workers' compensation case, the most important documentation are the medical records. What did the emergency room report say? What's the history that they have in there? What were their findings when you went into the emergency room? If you went to an emergency room, what doctor are you treating with? If it's an injury to your hand, is it an orthopedic doctor who specializes in hand injuries? And what do the records that he has indicate? Of course, it's always good if the doctor's relying on an MRI or some other testing that shows the injury, because it's a lot of time people hurt their backs and it's a strain, it's a muscle that you can't see or touch or feel on an MRI or in a CAT scan or anything like that, because it's not a broken bone. But the doctor can do testing to tell that there is an injury there. Spasm will show up. Spasm is an involuntary movement of the muscle that if the doctor sees it, he can say that's evidence of the injury that the person's complaining about. So subjective evidence is very good, but objective evidence is better.
And would you have an occasion to try to have witnesses that were either on the scene? Would you be looking to do that right away? Would you, in addition to the expert witness that might be a doctor or some other person, would you be including that in your arsenal, so to speak?
Sure, because most cases it's an injury at work and it's not really an issue of liability, because liability is not part of that. But to prove that the injury happened at work can sometimes be a little bit of an issue. If you're driving to work and you're not there yet, are you covered under workers' compensation law? If you're leaving work, at what point in time after you've checked out of the clock and have gotten into your car are you no longer covered by workers' comp?
Can you tell us a little bit about that?
Yeah, I actually think I know those answers.
Okay.
So there's some cases. One of them was a Leviton case where the person parked in the employee parking lot, which was across the street from the manufacturing plant, and had to walk across to get to the work. Hadn't checked in yet, but got hit. Well, he was already so far into his work day, he had parked on the employer's property. He was working towards getting into the building. He parked where they wanted him to park. He wasn't barred by the going and coming rule. In other words, he wasn't so far remote from his job that he wasn't covered. If he had been driving to work, got into an accident on 195 or 95 before he got off the exit to get to work, even if he was on the exit, probably not covered by workers' comp, because he's not doing anything for the benefit of the employer at that point. And that's sort of the test that you have.
That's good to know. Let's talk about money, David. Not yours, about your compensation, but about the person who's injured. So if their medical bills are covered, at what point and how, explain how you calculate what someone has for reimbursement, or how they live for until it goes to trial or whatever, a settlement.
So as I explained earlier, that you have the average weekly wage, and then there's the spendable net, or based off of that, based on how many dependents, and if you're on total disability versus partial disability, what you'll be compensated for. So as I like to say, the old days, when the workers' compensation statute that I started work under was first, and you would get 2/3 your average weekly wage plus some money for dependent benefits. It's a more complicated formula now that was basically put in when they reformed the Workers' Compensation Act under Governor Sondland, and tweaked it a little bit since, that you have to put in your gross wage and come up with the spendable base and all of that to come to whatever your compensation rate will be. So the long and short of it is your compensation rate is much lower than your average weekly wage, but it's not taxable. So there are no taxes coming out of it. So that's the first benefit that you need to know about. The other ones are, if you were injured and there's a loss of use to a body part, your arm is no longer fully functional, you can get recovery in Rhode Island for that injury, and there's a formula for that. And then the final one would be disfigurement. If you have scarring as a result of something, an explosion. We had a case once where a fellow was burned over a really good portion of his body. In Rhode Island, you're entitled to compensation for any disfigurement to your body. I have one that I probably could tell you about. I don't know. It's not really PG-13, so maybe I'll stay away from it. But long and short of it is the disfigurement is also something based on a formula, number of weeks on your average weekly income, and there's a certain formula as to the maximum that you can get and how they calculate what you'll get based on that.
If someone has a case and they're in treatment and perhaps they're in some portion of a rehab, they might get very close to all of that use back. Maybe they won't. It's not known, and maybe a doctor can't tell how far, how much, and what the ceiling is. How long does this go on before someone who's involved with a workers' compensation case says, let's settle this? How do you work with that?
And by settle it, we're not talking about settling the whole case, because that's a whole nother different set of issues that go into that, but the disfigurement or the loss of use. Well, if you are scarred, there's disfigurement. It's going to take a little while to heal, but there's a period, a process, and you don't try to recover, and you can't recover until you get a note from a doctor that says you've reached a medical end result. So you have a scarring, the doctor says, yep, it's a 4-millimeter scar, it's lateral to whatever, your body part is, and so forth and so on, and it's reached an end result. Then you can start talking to the insurance company about what you think the value of that injury or disfigurement is. If you can't agree on that, then you file a petition and the court will decide.
How do you help guide someone through what might be something that looks like, I will never be able to do this job again, however my employer offered me a slightly different job, it would be at a slightly different pay, it's a little bit lighter duty, but I will have employment, which means I will continue to have employment, versus if I wait, go to a trial, can't work, this is less money, what should I do? I have a family to support. How do you help people make a decision about what to do? Go for the sure thing that gives them ongoing employment at a reduced rate versus what might take longer to go to court, and who knows what that outcome would be.
So there is something called suitable alternative employment, which, if done properly by the employer and their insurance company, is almost a requirement that you do that. If the suitable alternative employment falls within all the limitations and allows you to do the job that is being offered to you, there is almost, you have to do it, unless you can show that there's other reasons why it's not suitable. The bottom line to your question, though, is if you've got a job that you really can never do again and you're totally disabled towards that job, the employer is going to have to pay you for an indefinite period of time. If you're partially disabled, which means you can do some things but not your job, then there's a period of 6 years that you have to get through what they call the gate to get payments. Beyond that, you have to show, sort of like that suitable alternative employment or Social Security standard, what other things you could do or can't do and why it's not, based on your circumstances, you'll ever be employable again, that gainful employment's out of the picture for you. So based on those issues, you would sit with the client and say, well, here are your alternatives. And then you have to go through it on a very personal level with them. This is how much money you might get in a lump sum. This is what can get put away for you. This is what you'd have to live on. What other things might you be able to do in your life so that you can go on with your life? And so you are part attorney, part financial planner, part social worker or psychologist, and you have to help them work through what all those possibilities are.
And what about the pitfalls? Gee, David, I think I might be able to do this job. It might give me less money, but I might be able to do this and stay gainfully employed for X number of years, but I'm not sure. Do you have to make that decision, which is a go, no-go switch, that if you take this option, that you shut down that option, which is workers' comp and all that road leads to?
Yeah, so depending on how it's set up, that is a possibility, and you have to be very careful that you go about it correctly so that you do have, did you call it the on-off switch, the ability not to have the off switch turned off permanently on you. So that's something you need to work through with an attorney to make sure that if there is going to be an offer of employment, that it's done in such a way that if you can't do it, or it turns out that they want to stop you from doing it because they don't want to offer that position anymore, that you haven't signed documentation or done something to turn the off switch off on your claim.
Good to know. And how about the settlement of cases? You mentioned trial, pre-trial. There's also, is there an arbitration? Is there a binding arbitration? What does that look like, David?
Workers' comp does not really have that process. In workers' comp, the closest thing you get to an arbitration is the pre-trial, where you and your attorney and the attorney for the insurance company and / the employer meet with the judge and talk back and forth. Now, I've had cases where we've gone to pre-trial and then there's a claim for trial, and during that process where the case is pending, discovery is being done, depositions are being done, we've negotiated out settlements, and we have gone back to the court and talked to the judge about certain issues that we're having and had some advice from that judge.
And when it comes to the employer having an experience rating, a different amount of money that he will have to pay, how much does that actually factor in when he's deciding whether or not he will just sign off on this being a workers' compensation case, or, for example, you might be hired to defend him and say this is absolutely not legit, or I don't need to pay for it? Can you help evaluate that for the employer's standpoint?
So I don't do any work from the employer's stand of view for an insurance company.
Okay.
But that being said, what I can tell you as an employer is you do have a right to sign off on a settlement of a case, and you have the right to have your voice heard on that. But for most instances, the insurance companies only settle cases that they think is in their best interest to settle, and usually if it's in their best interest to settle, as the employer, it's going to be in your best interest to settle as well. As far as how experience ratings go and how it's going to affect your rate, I can't answer that question.
Fair enough. And what about you fearing retribution, or there actually being some retribution, some harassment, some taunting? What happens in that case, David, if you went back to work and here's the situation? We're talking about a different kind of case?
Now you're talking about a harassment case, an employment law type of case that falls into a whole other category. And you do have rights, and if people step over the line with you, and we've talked about this on other occasions, I'm sure, that the employer, you put your employer on notice, this has happened. If it's your employer doing it, obviously you tell them that this isn't appropriate. And you have the right to go to the Equal Opportunity Employment Office and complain about what's going on, the commission, or whatever other rights that an employment attorney would tell you to take.
Are these cases hard to prove, David, workers' compensation in general?
Usually not. Usually it's pretty straightforward. You got hurt at work, and again, we didn't get into the details of this, but if you're acting in the course of your employment and you get injured by something that happens in the course of your employment, it's compensable for the most part. If there's a lot of fooling around and things outside of the scope of your employment, those are where the gray area issues may come in. But for the most part, generally, they're not hard to prove. Where there are issues, that's where we talked about at the beginning, making sure you have the documentation, the witnesses, and all of that to show that, yeah, this happened at work and there's no question it happened at work. And telling your employer that it happened at work is the first step in that.
And before we close, there's one other question that I have quickly. Suppose you have a freelancer. This is not a paid employee, as you had described earlier. Does that freelancer, casual labor person have any recourse if something happens at work?
So now we're getting into a really technical and difficult area that'll take a lot of time, but let's just say an independent contractor who's truly an independent contractor doesn't fall under your comp.
Good to know. We certainly did cover quite a few issues related to workers' compensation. We hope that this has been helpful to you. We thank you for tuning in. Our discussion of legal matters will continue. Join us.